The courtroom was so quiet you could hear the clock on the wall. Beatrice Calloway, 78 years old, silver hair pinned neatly back, slightly curved from decades bent over a sewing table, sat alone at the defendant's table. Across the room, Reginald and Victoria Calloway sat behind two attorneys in charcoal suits with leather briefcases that cost more than Bee's first sewing machine. Judge Margaret Chen looked up from her papers. She said, "Mrs. Calloway, where is your attorney?" Bee stood. Slowly, the way she did everything with the specific, unhurried quality of a woman who had spent 60 years making things by hand and had learned that rushing produced mistakes you couldn't undo. She said, "I don't have one, Your Honor." A sound from Reginald's side of the room. A quiet laugh, quickly suppressed or not suppressed, just quieted to the level considered appropriate for a courtroom. Victoria's mouth curved. The gallery stirred. A 78-year-old retired seamstress defending herself against two of the county's senior estate attorneys. This was not going to be a proceeding. It was going to be a formality. Judge Chen said, "Are you certain, Mrs. Calloway? The claims being brought against you are serious. The Calloway family alleges improper acquisition of Edmund Calloway's estate." Bee did not answer immediately. She reached up, both hands moving with the deliberate precision of someone performing a task they have done 10,000 times and intend to do correctly. She unfastened the top button of her wool coat, the heavy one, the one she had been wearing since the morning Edmund died, the one she had knit herself from the yarn he had given her for their 40th anniversary. The second button. The third. Every eye in the room was on her hands. Reginald said in the tone of a man performing patience for an audience, "Is she planning to use her coat as her attorney?" The fourth button. Bee slipped the coat from her shoulders. She turned it over. The lining, hand-stitched the work of someone who knew how to make seams that held, had been opened along one edge and carefully, precisely re-sewn, and stitched into that lining, secured by the smallest, most careful stitches she had ever made, was a document, yellowed at the edges, folded to fit the space exactly. She removed it. She held it in both hands. She said, "I don't need an attorney." Her voice was even, the voice of a woman reading a measurement, calling a number, naming a thread count. Exact, unhurried, the voice of someone who has been working toward a specific result and has arrived at it. She said, "Because I have this." She placed the document on the table. The room was completely still. The stitch that saved everything. The time-lapse of a life could fit in a thimble, Bee had always thought. Not because life was small, because the essential things were a length of thread, a needle, a steady hand. The rest was decoration. She had opened the alteration shop on Millbrook Street in 1971, the year she turned 26, with $300 saved from 8 years of working in other people's shops and a sewing machine that was already second-hand when she bought it. The shop was small, 2 rooms, one for fittings and one for the actual work, with a bell above the door that rang whenever someone entered. She had sewn that bell's ribbon herself, a narrow length of blue grosgrain that she replaced every few years when it frayed. She had never married. Not from lack of opportunity. There had been men who had asked over the years, and she had considered each of them with the same careful attention she brought to a difficult seam. But something had always been wrong. Not dramatically wrong. The small wrongness of a garment that was almost right but would never sit correctly no matter how many adjustments you made. She had learned early to recognize the difference between a fitting problem and a design problem. You could fix a fitting problem. A design problem required starting over. She had been waiting without knowing she was waiting for something designed correctly. Edmund Calloway walked through her door on a Tuesday afternoon in April of 1995. He was 67. She had learned his age later. At the time, she saw a tall man with white hair and the specific posture of someone who had been carrying responsibility for a long time and had made peace with the weight of it. He was holding a jacket. A good jacket, old, the kind of quality that lasted if you maintained it. He said, "I was told you're the best in the county for wool." She said, "Who told you that?" He said, "My housekeeper." She said, "If the wool can be saved, B. Mason can save it." She took the jacket. She examined the lining worn at both sides, the stitching beginning to separate at the left sleeve. Good bones. The fabric itself still sound. She said, "It can be saved. It'll take a week." He said, "Take 2. Do it right." He came back in a week. He stayed for an hour. He came back the following Tuesday with another jacket, and the Tuesday after that with a coat. By the 4th Tuesday, she understood that the garments were a pretext, and she found that she did not mind, and that not minding was itself a kind of answer to a question she had not known she was being asked. They were married in the spring of 1997. The ceremony was small. A judge, 2 witnesses, the dress Bea had made herself from a cream-colored wool that Edmund had sent from his mill. Edmund had wanted to invite his children. They had declined. He had been hurt by this in the way that parents were hurt by their children's failures, not with surprise, but with a grief that had been anticipated, and arrived anyway, unchanged by the anticipation. There had been 2 empty chairs at the reception table. Bea had looked at them once, and then looked away and had not looked at them again. The years that followed had the quality of a good fabric, not showy, not dramatic, but sound. Edmund had been a man who loved carefully and demonstrated love through attention rather than declaration. He learned which thread colors she kept near the window for the afternoon light. She learned which chapter he read when he couldn't sleep. They had disagreed about many things and agreed about the important ones, and had built in the rooms of the Calloway house the specific warmth of a life shared by 2 people who had chosen each other deliberately and continued choosing. Reginald and Victoria had come to the house on occasions, Christmas sometimes, Edmund's birthday. They were cordial in the way of people performing cordiality for an audience, the warmth present in the form, but not the substance. They called her Mrs. Calloway in the tone that communicated the name did not belong to her. She had never asked Edmund to address this. He had addressed it anyway in his own way in his own time without telling her. It was 2005 when he called her into the study. She remembered the evening clearly, the lamp on the desk, the smell of the old books he kept along the far wall, Edmund in his chair with a folder in his lap. He had been 77. She had been 60. They had been married for 8 years. He said, "Bea, come sit down. I have something to show you." She sat in the chair across from him, the chair she had reupholstered herself 3 years before, a deep green wool because the original fabric had finally given up. He opened the folder. He said, "I made this 20 years ago, before we met. I updated it when we married, and I've kept it current since. I want you to read it." She read it. It was a trust document, an irrevocable trust, the kind that did not pass through probate, that transferred directly to its named beneficiary upon the grantor's death. She had not known the legal language at the time, but she understood the essential structure. Edmund had placed the house, the mill, and the primary accounts inside this document, and the named beneficiary was her. She had looked up from the pages. She said, "Edmund, you didn't tell me." He said, "I didn't want you to carry it. I wanted you to live here the way you should live here as my wife, not as someone defending her position. I wanted the defense to already be done." He said, "But I need you to keep this safe. Don't give it to a bank. Don't give it to an attorney. Keep it somewhere that only you know about." She had looked at the document in her hands, at the careful legal language, the notary's seal, the date. She had said, "I know exactly where to keep it." He had looked at her. He had said, "I knew you would." In the courtroom, sitting at the defendant's table with the coat across her lap, Bea thought about that evening, about the lamp on the desk, about Edmund's hands older than her own, but steady, holding the folder out to her, about the specific weight of a document that had been kept safe for 20 years, not in a vault, not in a safety deposit box, but in the place he had trusted her to choose. Her hands moved to the coat. She did not open it. Not yet. She smoothed the surface of the wool with her palm, the gesture of a woman checking her work, confirming that the stitches had held. They had held. They had been holding since the evening she had sat by the lamp in her sewing room with a seam ripper and a needle and thread, and had done the most careful work of her life. 20 years of careful work, all of it holding. Judge Chen had given her the floor at 10:17. Bea stood. She did not have notes. She had not prepared remarks in the way that attorneys prepared remarks, with structure and argument and the anticipation of objection. She had prepared the way she prepared everything, by knowing her material completely, by understanding every seam and every join, by being certain that what she was presenting would hold under examination. She said, "Your Honor, I'd like to tell the court about a night in 2005, if I may." The judge said, "Proceed." She described the study first, the lamp, the books, the chair she had reupholstered. She described it the way she described things she had known well for a long time, with the specific detail of someone who had been paying attention, not for the purposes of recollection, but simply because paying attention was how she moved through the world. She said Edmund had been thinking about this for a long time before he told me. I could see that from the way he handled the folder, the way you handle something you've taken out and put back many times. She said he told me he had made the trust in the year 2000, 3 years after we married. He said he'd had an attorney draw it up, not the family attorney, someone he found on his own, someone who had no prior connection to the Calloway name. He said he wanted it done cleanly without anyone who might mention it to the wrong person. She paused. She said I asked him why he hadn't told me sooner. He said he didn't want me living in the house as someone who knew she was protected. He wanted me to live there as his wife. He said the protection was for later, for after he was gone, when I would need it, and he wouldn't be there to provide it any other way. The room was quiet. Bee's hands were resting on the railing of the witness area, still the way her hands were always still when she was working, when the motion was internal and the exterior had gone quiet. She said he explained what an irrevocable trust meant. He said once it's made, B, it can't be undone. Not by me, not by anyone. I could change my will 10 times and it wouldn't matter. The trust stands above the will. The assets inside it pass directly to you. No probate, no contest. She said, he said, and I want to be precise about this because I've thought about these words many times. He said, I know my children. I know they'll make this difficult for you, but this document is stronger than any attorney they can hire. Reginald's chair made a sound against the floor. He said, this is fabrication. If a trust of this magnitude existed, it would have appeared in the estate proceedings. It would have been disclosed. If she had this document, she would have produced it immediately, not stood up in court, and told a story about it. His attorney Hargrove was already on his feet. He said, Your Honor, the defendant is making claims without documentation. We request that she either produce the original instrument immediately or cease these representations. Judge Chen looked at Hargrove. She said, Mr. Hargrove, the defendant is in the middle of her statement. She will have the opportunity to produce documentation at the appropriate moment. Sit down. Hargrove sat. Reginald did not sit immediately. He looked at Bee with the expression of a man who has decided that what he is hearing is a performance and is waiting for it to collapse under its own weight. Then he sat. Bee continued. She said Edmund explained the trust that night. He explained every section. He was a patient man. He wanted me to understand what I had, not just that I had it. We sat in that study for 2 hours. She said at the end he asked me to keep the document. He said not in a bank box, not with an attorney, somewhere only you know, somewhere they wouldn't think to look. She said I thought about it for a week, and then I knew where it should go. She said I'm a seamstress. I've spent my life working with my hands, with fabric, with the things that ordinary people use every day and don't notice. Nobody looks at a seamstress's coat and thinks that's where the important things are kept. Nobody looks at stitches and sees strategy. She said Edmund trusted me to keep it safe, so I did what I know how to do. She said I made it safe the way I make everything safe with my hands, with thread, with the patience to do the work correctly so it would last. Her hand moved to the coat across the railing. She said I sewed the trust into the lining of this coat 3 weeks after Edmund gave it to me. I used a thread that matched the original lining exactly. You'd have to know to look for it to find the seam. I've worn this coat every winter since. When Edmund died, I started wearing it every day. She said not because I was cold. She did not finish the sentence. She did not need to. The room understood what she meant. The specific understanding of a room that has been told something true and is processing the weight of it, that a woman had carried a legal document against her body for 20 years, not as a strategy, but as a form of keeping faith with the person who had trusted her with it. Judge Chen had her pen in her hand but was not writing. Reginald was looking at the coat. Victoria, who had been composed throughout the morning with the specific composure of someone who had reviewed the likely scenarios in advance and believed she had accounted for them, had gone still in a different way. The stillness of a person who has encountered a variable they did not account for. Hargrove leaned toward his co-counsel. Whatever he said was too quiet to be heard. Judge Chen said, "Mrs. Calloway." B looked at her. The judge said the court needs to see the original instrument. If you have it, if it is what you say it is, this is the moment to produce it. B nodded. She said, "Yes, Your Honor." She picked up the coat. She held it for a moment in both hands, the weight of it, the wool she had chosen, the years it had been worn. Edmund's anniversary yarn. The lining she had opened and re-sewn with the smallest stitches she had ever made, stitches so small they were almost invisible stitches made with the understanding that they needed to hold for as long as they needed to hold. They had held for 20 years. She began to undo them. She began with the buttons. There were 6 of them, the same buttons she had sewn onto this coat 23 years ago, small wooden ones the color of dark honey chosen because Edmund had said they reminded him of the floors in the old part of the mill. She had kept that detail. She kept most details. The first button. The room was already still, but it became more still, the specific graduated stillness of people who have understood that something is happening and are adjusting their breathing accordingly. The second, Hargrove said from the plaintiff's table. "Your Honor." Judge Chen said, "Mr. Hargrove, sit down." He sat. The third button. B was not performing this. That was the thing about it, she was not moving slowly, for effect was not drawing out the moment for the benefit of the audience. She was moving at the pace she always moved when she was handling something that required care. The pace of a woman who had learned over 60 years of working with her hands that the things worth doing were worth doing at the speed they required, and no faster. The fourth button, she could feel the room, not see it. Her eyes were on her hands, on the buttons on the coat, but she had spent a long working life in small spaces with other people fitting and adjusting and standing close to strangers while they stood in front of mirrors, and she had developed the specific sensory awareness of someone who reads a room through its sounds and its silences and the quality of the air. She could feel the held breath on Reginald's side of the room, the particular quality of Victoria's stillness, which was different from the stillness of someone waiting and more like the stillness of someone who has stopped being able to move. The fifth button, she thought about Edmund, not as a deliberate act of memory. He simply arrived the way he arrived in the mornings when she woke up, and the afternoons when she sat in the garden, and the evenings when the light changed, and she looked at the chair where he used to read. He arrived as a presence rather than a thought, the warmth of a man who had loved her in the specific way of someone who saw what was actually there. She had loved him back in the same way. The sixth button, she slipped the coat from her shoulders. She held it for a moment in both hands the way you hold a garment before you turn it with the specific respect for fabric that a lifetime of working with fabric produces. Then she turned it. The lining. It was the original lining, a dark gray wool chalice, smooth against the hand, the kind of material that lasted if you treated it correctly. She had replaced it once in 2010 when the original had finally worn through at the seams. She had done it herself, as she did everything herself, and she had taken the document out and placed it in the new lining with the same care she had placed it in the first. She had stitched it back in, and there it was. The stitching was at the bottom edge of the lining, a line of hand stitches 2 inches above the hem, running the full width of the coat. To anyone who did not know to look for it, it would have appeared to be a simple reinforcement seam, the kind a careful seamstress added to high-wear areas. The thread matched the lining exactly. The stitches were even 114 of them, she knew without counting, because she had counted them the night she made them and had not forgotten. Between those stitches and the outer shell of the coat, sealed in a length of clear archival plastic, she had purchased from a preservation supply catalog and cut to size the trust document. Every page, every notary seal, every signature, protected from moisture, from light, from the specific entropy that attacked paper over time. Intact. She placed the coat on the railing before her. She looked at the stitching for a moment. Then she took from her pocket the small pair of scissors she had carried every day of her working life, the silver ones 6 inches with the loop handles worn smooth, and she cut the stitching. One pass. Clean. 60 years of muscle memory. She set the scissors down. She reached into the opening she had made and drew out the plastic sleeve. She set it on the railing. The document inside was visible through the clear plastic, the cream-colored pages slightly yellowed at the edges, the heavy legal formatting of a document prepared with care. The notary's seal was visible on the final page. The date was visible. The signatures were visible. She turned it to face the room. The sound that came from Reginald Calloway was not a word. It was the sound of a man whose breath had done something involuntary, the specific exhale of someone who has received information that rearranges a belief they have held for years and has not yet had time to form a response. Victoria's hand was on the railing of the plaintiff's table. Her knuckles were white. Hargrove was on his feet. He said, "Your Honor, this alleged document was not disclosed in pretrial proceedings. It was not included in any filing. The admissibility of evidence that has been concealed in a garment." Judge Chen said, "Mr. Hargrove." He stopped. She was leaning forward. Not far, a few inches, the specific forward inclination of a person who is looking at something closely. Her eyes were on the plastic sleeve on the railing, on the document visible inside it, on the stitching along the coat's lining. She said, "Bring that to the clerk, Mrs. Calloway." B picked up the sleeve. She carried it to the clerk's desk. She set it down. Then she turned. She walked back to the defendant's table. She picked up the coat. She held it. And then she said her voice for the first time in the morning's proceedings, carrying something other than the level calm of a woman stating facts. Not weakness, not fear, the specific resonance of someone speaking about something that has cost them something real. She said, "Your Honor, my husband trusted me with this." She said he knew I would be standing somewhere like this someday. He knew his children would do what they've done. He prepared this document 23 years ago because he understood that paper, kept correctly, outlasts everything else. Outlasts anger and outlasts grief and outlasts the desire of people who believe they are owed what was never theirs. She said he asked me to keep it safe. He said he trusted me to find the right place. She looked at the coat in her hands. She said I kept it where I keep everything that matters, close to me, in the work. She set the coat across the back of her chair. She sat down. She folded her hands on the table. The clerk had opened the plastic sleeve and was handling the document with the careful two-handed attention of someone who understands they are holding something significant. Judge Chen was watching the clerk. Then she looked at the plaintiff's table. Reginald Calloway was sitting in his chair. He looked for the first time in the morning's proceedings like a man who was not certain what came next. Victoria had not moved. The hand on the railing was still closed. The court reporter's fingers had gone still on the keys. And in the silence of Courtroom 4, with the clock on the wall, marking the half-hour, Beatrice Calloway, 78 years old, retired seamstress, the woman they had been laughing at 90 minutes ago, sat at the defendant's table, with her hands folded, and waited for the law to do what Edmund had trusted it to do. Judge Chen called the recess at 11:43. She said the court will stand in recess while the document is examined. We will reconvene at 2 o'clock. Mr. Hargrove, your objection to admissibility is noted and will be addressed when we resume. Mrs. Calloway, the document remains with the clerk. She stood. The room stood with her. The examination took place in a room on the 3rd floor that the court used for exactly this purpose, a narrow room with good lighting and a long table, and the specific institutional quiet of a space where serious work happened without ceremony. The document examiner's name was Aldrich. He was 56, with the compact efficiency of someone who had been doing precise work for a long time and had stopped finding it interesting in the way that mastery sometimes replaced interest with something quieter and more durable. He had examined questioned documents for the court for 19 years. He had been called in on shorter notice than this. He examined the document for 2 hours and 11 minutes. B sat in the hallway outside the examination room on a wooden bench that had been there long enough to have developed the specific concavity of a bench that had held a great many people waiting for a great many things. She held the coat across her lap. She was not anxious. This surprised her slightly. She had expected to feel something more effortful during this waiting, some version of the held breath that the rest of the courtroom had been holding when she opened the lining. But what she felt was closer to the feeling she had after finishing a long and difficult piece of work, the specific quiet of a task, completed the particular stillness of hands that have done what they were asked to do and are resting. Edmund had trusted the document. Edmund had trusted her. She had kept it. The examiner would find what Edmund had made the real thing made correctly by a careful man who had understood that the document needed to be beyond question. Edmund had been a builder. He had built things to last. She smoothed the coat. She waited. At 1:55, Hargrove and his co-counsel emerged from a conference room down the hall. She watched them walk back toward the courtroom without looking at her. Hargrove had the expression of a man revising his position, not panicking, not defeated, but working. She recognized the quality of it. She had seen it in clients who had come to her with a garment that was not what they had hoped, who were standing in the fitting room working out what could still be saved. Sometimes things could be saved. Sometimes the design was wrong and no amount of adjustment would fix it. She thought Hargrove was beginning to understand which kind of problem he had. At 2:00, Judge Chen returned to the bench. She said the court has received the examiner's preliminary findings. Mr. Aldrich, please summarize your conclusions for the record. Aldrich stood at the front of the room with his folder. He said the document submitted to this court as the Edmund James Callaway Irrevocable Trust, dated March 14, 2000, has been examined for authenticity. Examination included analysis of the paper substrate, the ink composition, the notary seal, and the signatures of the grantor and the notarizing attorney. He said the paper is consistent with archival quality legal document paper, manufactured in the period 1998 to 2002. The ink composition is consistent with the period of the stated execution date. There is no evidence of alteration, erasure, or substitution of any page or section. He said the signature of Edmund James Callaway was compared against known, authenticated exemplars from his business records, including corporate filings and deed transfers on record with the county. The signatures are consistent. There is no indication of forgery. He said the notary seal belongs to a notary public whose commission was active in this jurisdiction in the year 2000. The notary's records obtained from the State Archive confirm a notarization on the date stated in the document. He closed his folder. He said the document is authentic. There is no evidence of fraud, alteration, or any irregularity in its execution. Hargrove stood. He said, Your Honor, even accepting the authenticity of the document, the plaintiffs maintain that an irrevocable trust of this nature may be subject to challenge on the grounds of he paused, the pause of a man selecting the most viable argument from a diminishing list on the grounds that the grantor's intent may have been superseded by subsequent actions, including the will executed in 2018, which, the judge said, Mr. Hargrove, an irrevocable trust is not superseded by a subsequent will. That is the definition of irrevocable. The trust controls the disposition of the assets placed within it, regardless of any testamentary instrument executed afterward. You know this. Hargrove said the plaintiffs would argue that the trust may have been abandoned by conduct. The judge said there is no evidence of abandonment before me. The document is authentic and unaltered. The trust was established in 2000 and has remained in continuous effect. Is there something else? A pause. Hargrove said the plaintiffs would note that the manner in which the document was preserved raises questions about. The judge said, the manner in which a document is preserved has no bearing on its legal validity. A trust document kept in a filing cabinet and a trust document kept in a coat lining are equally valid instruments. The question before this court is whether the document is authentic and legally effective. The examiner has answered both questions. She looked at Reginald. He was sitting very still. Victoria beside him had the expression of a woman who has been running a calculation and has arrived at a number she did not expect. The judge said, "Mr. Calloway, you have heard the examiner's findings. I'd like to give you the opportunity to address the court before I proceed." Reginald looked at Hargrove. Hargrove said quietly, the quiet of a professional delivering a professional assessment, "There is nothing productive to say at this juncture." Reginald looked at the front of the room. He looked at Bea. She was sitting at the defendant's table with the coat across her lap, and her hands folded and the expression of a woman who has finished a long piece of work and is allowing herself to be still. He said nothing. The judge said, "Very well." She made a notation. She said, "We will take a brief recess and then reconvene for closing arguments and the court's ruling. The document will be marked as Exhibit A and entered into the permanent record." She stood. The room stood with her. Bea remained seated for a moment after everyone else had risen. She looked at the coat in her lap. She thought about the night she had sewn the document into the lining, the lamp in the corner of her sewing room, the needle and the thread she had chosen the patience required for stitches that small, the understanding that she was making something that needed to last for as long as it needed to last. Edmund had said, "I trust you to find the right place." She had found it. She looked at the cut edge of the lining, the clean line where her scissors had gone through the stitching that morning, one past 60 years of hands, knowing exactly how much pressure was needed and no more. The stitches had held. Edmund had built the document. She had kept it safe. Between the two of them, they had done everything that needed to be done. Hargrove requested the cross-examination at 2:47. He framed it as a matter of due process. The plaintiffs had a right to question the defendant regarding the document's provenance and the circumstances of its production. Judge Chen allowed it with the specific brevity of someone who understood what was being attempted and was going to permit it anyway, because the record needed to show that every avenue had been available. Bea took the stand. Hargrove approached with the measured pace of a man who had reassembled his confidence during the recess and was presenting the reassembled version to the room. He was still good at this. 31 years of practice did not dissolve in an afternoon. He still had the voice, the posture, the ability to make a question sound like a statement of settled fact. He said, "Mrs. Calloway, you are by profession a seamstress. Is that correct?" Bea said, "Retired seamstress, yes." He said, "You have no legal training." She said, "No." He said, "No education in estate law, trust instruments, or the requirements for a valid testamentary document." She said, "That's correct." He said, "So when Edmund Calloway showed you this document in 2005 and told you it was an irrevocable trust, you had no independent means of verifying that claim. You took his word for it." Bea said, "I took his word for many things over 22 years. He was generally right." A sound from the gallery, not quite laughter, something softer. Hargrove moved past it. He said, "But you couldn't read the legal language and understand its implications. You couldn't assess whether the document had been properly executed. You're not qualified to make those assessments." Bea said no. But Edmund was. He spent 2 hours explaining it to me, and the examiner this morning spent 2 hours confirming it independently. Between the two of them, I believe the question of whether the document was properly executed has been answered. Hargrove's pace slowed fractionally, the kind of adjustment that was visible only to someone paying close attention. He said, "Let's discuss the circumstances under which this document was prepared. You testified that Edmund used an attorney outside the family's usual legal counsel." She said, "That's what he told me." He said, "Doesn't that strike you as unusual? A man of Edmund Calloway's standing with an established relationship with a reputable firm going outside that relationship for a major estate instrument." Bea said, "He told me why he did it. He didn't want anyone connected to the family to know about the trust until it was time for it to be known. That seems like a reasonable decision to me given what's happened in this courtroom today." The gallery stirred again. Hargrove said, "You're suggesting that Edmund anticipated this litigation." Bea said, "I'm saying Edmund knew his family. He loved his children, but he knew them." Hargrove shifted. He said, "Mrs. Calloway, let's discuss Edmund's state of mind when this document was prepared. In the year 2000, Edmund Calloway was 72 years old. He had recently undergone cardiac surgery. He was by multiple accounts in a period of significant physical and emotional vulnerability. He said, "Is it possible? Is it not possible that someone in that condition might be susceptible to influence? That a younger wife present in the household, closely involved in his daily care, might have B said I was not present when the trust was made." Hargrove paused. She said Edmund prepared that document before he told me about it. He made his decisions and then he told me what he had decided. That was how he worked. He didn't consult me about the trust. He made it, and then 5 years later he showed it to me. There's nothing in that document that I requested or suggested. If you're asking whether I influenced him, I wasn't in the room. I didn't know it existed. Hargrove had prepared for various answers. He had not, she could see, prepared for that one. He recovered. He said, "You can't prove you weren't influencing him in a more general sense in the years of the marriage in the Wu." Judge Chen said, "Mr. Hargrove, you're asking the witness to prove a negative. Move on." He moved on. He circled for several minutes through questions about the marriage, about the household, about B's role in Edmund's financial affairs. She answered each question in the same register, not defensively, not with the energy of someone fighting, with the flat, precise accuracy of someone reporting what was true. She did not embellish. She did not minimize. She gave him what the question asked for and nothing extra. He was running out of ground. She could see it in the quality of his pauses, the pauses getting slightly longer, the questions slightly less specific. A seamstress learned to read the shape of things. What she was reading was the shape of a man who had planned for a different kind of witness and was adjusting in real time to the one he had. He said, "Mrs. Calloway, a final question." He said, "Why didn't you hire an attorney?" The room settled. This was the question he had been building toward. She understood that now. The whole cross-examination had been moving here to this question, which was designed to imply that her failure to retain counsel was itself evidence of something, naivety or desperation or a plan that depended on spectacle rather than a substance. She looked at him. She said, "I didn't need one." He said, "You're facing a complex estate litigation with 2 experienced attorneys on the opposing side, and you didn't feel you needed legal representation." She said, "I had the document. The document is what matters. An attorney would have filed it with the court in a pretrial motion, and it would have appeared in a folder, and Reginald and Victoria's attorneys would have read it, and they would have settled, or they would have proceeded, and the document would have done what it does in either case. It doesn't need a lawyer to make it valid. It's valid because Edmund made it correctly." She said, "I chose to bring it here myself. The way I brought it, that was my choice. But the document is what it is, regardless of how it arrived." She paused. Then she said, "You asked why I didn't hire an attorney. I'd like to ask you something in return if the court will permit it." Judge Chen said, "I'll allow it." B looked at Hargrove. She said, "I had no attorney. I had a coat and a pair of scissors and 60 years of knowing how to keep important things safe. Reginald and Victoria had 2 of the best estate attorneys in this county. Between the 2 approaches, only one of them produced a result this morning." She said, "I don't think the question is why I didn't hire a lawyer. I think the question is why 2 lawyers weren't enough." She turned to look at Reginald, not with triumph, not with the heat of a woman who has been wronged and is enjoying the accounting, with the specific level attention of a woman who has been watching someone for a long time and is now simply looking at them clearly. She said, "You came here today because you believed I was easy. You believed that a woman who spent her life making other people's clothes couldn't possibly understand how to protect herself. You were wrong about that, not because I'm unusual, but because you weren't paying attention." She said Edmund paid attention. For 23 years he paid attention, and he made sure I had what I needed. She said, "I think that's the answer to your question." Hargrove was standing very still. He turned. He walked back to the plaintiff's table. He set his notepad down. He leaned toward his co-counsel. The co-counsel leaned toward Reginald. What passed between them was too quiet for the room to hear. Reginald's hand came down on the table. Not a strike oppressed the motion of a man pushing against a surface as though the surface might yield. It did not yield. Victoria was looking at the front of the room. She had the expression of a woman who has arrived at a conclusion she had been avoiding and has finally allowed herself to arrive at it. Hargrove straightened. "He said no further questions, Your Honor." The gallery was very quiet. Bee stepped down from the witness stand. She walked back to the defendant's table. She sat down. She picked up the coat. She smoothed it once the even practiced motion of a woman who has worked with fabric her whole life and returns to the gesture without thinking the way a person returns to what is true when everything else has been said. The clock on the wall marked 3 o'clock. Judge Chen returned to the bench at 3:20. She had been in her chambers for 40 minutes. When she came through the door and the bailiff called the room to order and everyone stood, she moved with the same economy she had moved with all day. Nothing hurried. Nothing performed the specific, unhurried authority of a woman who had made her decision and was now going to state it. She sat. She opened the folder before her. She looked at the room. She said this court has heard the matter of Calloway versus Calloway regarding the estate of Edmund James Calloway. The court has reviewed the documentary evidence submitted by the defendant, the examiner's findings regarding the authenticity of that evidence, and the arguments presented by both parties. She said the court finds as follows. She said the Edmund James Calloway Irrevocable Trust, executed on March 14, 2000, and authenticated by this court's document examiner, is a valid legal instrument. It was properly executed, properly notarized, and has remained in continuous effect from the date of its creation. It has not been amended, revoked, or superseded by any subsequent instrument, including the will executed by Edmund Calloway in 2018. Under the law of this state, an irrevocable trust controls the disposition of the assets placed within it and is not subject to modification by testamentary instrument. She paused. She looked at the plaintiff's table. She said the assets held within the Edmund James Calloway Irrevocable Trust, including the Calloway residence on Millbrook Road, the Calloway Textile Mill, and all associated business interests, the primary investment and savings accounts detailed in Schedule A of the trust instrument, and all other assets enumerated therein pass in their entirety to the named beneficiary. She said that beneficiary is Beatrice Mason Calloway. The room received this the way rooms received irrevocable things, not with a sound, but with a quality of stillness that was different from the silence that had preceded it. The silence before the ruling had been the silence of waiting. This was the silence of something completed. Reginald Calloway moved. He pushed his chair back and started to rise, and Hargrove's hand came down on his arm, not roughly, with the specific firm pressure of a professional, preventing his client from making a mistake that could not be unmade. Reginald looked at Hargrove. Hargrove gave a small, precise shake of his head. Reginald sat. Victoria had turned away from the front of the room. Her shoulders were doing something, a movement too small and too controlled to be called shaking, the kind of contained motion that was either grief or rage, and was at this distance indistinguishable. Judge Chen continued. She said the court further finds that the claims brought by the plaintiffs in this matter were without evidentiary foundation. The plaintiffs asserted that the defendant had improperly acquired assets belonging to Edmund Calloway's estate. The evidence demonstrates that the primary assets at issue were not part of Edmund Calloway's probate estate and were never available for distribution by will or intestacy. The plaintiffs brought these claims against a defendant who had the right to the property in question and has had that right for 23 years. She said the court takes note that this litigation required the defendant, a 78-year-old woman, proceeding without counsel to appear in this courtroom and defend claims that a reasonable examination of the public record would have revealed to be without merit. The Calloway Trust instrument, while not filed with the probate court, was properly executed, and its existence was discoverable through due diligence. She said the court finds that this action bears the characteristics of vexatious litigation, that is, legal proceedings brought not with reasonable expectation of success, but for the purpose of harassment and coercion. The court is not prepared at this juncture to make a formal finding of bad faith, as that would require a separate proceeding. However, the court is prepared to act on the consequences. She said the plaintiffs are ordered to bear all costs of this proceeding, including the court's costs, the examiner's fees, and reasonable compensation for the defendant's time and preparation to be calculated at the standard rate for self-represented litigants in this jurisdiction. She looked at Hargrove. She said counsel for the plaintiffs is cautioned that the court's restraint in this matter reflects the benefit of the doubt extended to officers of this court. That benefit is not unlimited. She closed the folder. She looked at the room at B's table, at the plaintiff's table, at the document on the clerk's desk that had been sewn into a coat lining for 20 years and had arrived in this courtroom in a plastic sleeve and had done exactly what Edmund had made it to do. She said, "I want to say one thing before I close this matter, and I want the record to reflect it." She said the defendant in this case came to this courtroom without an attorney, without a pre-trial filing, without any of the procedural mechanisms that experienced litigants use to establish their position before they walk through the door. She came with a document in a coat. She said that document was valid. It was authentic. It was precisely what she said it was, and she kept it safe for 23 years using the skills she had and the judgment she trusted. She said the law does not require any particular method of document preservation. It requires that the document be authentic and unaltered. This one was both. She said this court does not have occasion to comment often on the manner in which people protect what matters to them, but the court notes that what occurred here today was not an accident. Edmund Calloway made something durable, and he gave it to someone he trusted to keep it. She kept it. The result is what it is. She picked up her gavel. Reginald Calloway was looking at the table in front of him. He had the expression of a man sitting inside the ruins of a certainty that had structured his understanding of the world for 30 years. Not the dramatic devastation of someone receiving unexpected news, but the specific, quieter devastation of someone whose expectation has been definitively corrected. He had believed for 30 years that B was a woman who had attached herself to his father's resources without legitimate claim. He had believed it with the confidence of someone who had never examined the belief because the belief had never needed examining. It had needed examining. He had not examined it. Victoria was not looking at anything. Her hands were in her lap. Her face was turned toward the window, the high window on the east wall of Courtroom 4, the one that showed a rectangle of October sky. Bea was not looking at either of them. She was looking at the coat on the table before her. The coat Edmund had given her the yarn for, the coat she had knit in the evenings of the winter of 2001 in the sitting room while he read, the coat she had worn through every winter since, and every day since he died. The coat whose lining she had opened with her silver scissors that morning, one clean past 60 years of hands, knowing exactly the right pressure. The document was on the clerk's desk. The coat was before her. Judge Chen brought the gavel down. She said, "Court is adjourned." Bea stood. She reached for the coat. She put it on. The first button, the dark honeywood worn smooth. The second, the third, the fourth, the fifth, the sixth. The lining was open now. The stitching cut the document gone to the clerk's desk, where it would be copied and certified and returned, and would live in whatever file the court kept for matters of this kind. The coat was lighter than it had been this morning. She had carried the trust for 23 years, and now the court was carrying it, and she was left with a coat that was in the most technical sense, just a coat wool, 6 buttons a cut, lining a useful garment for a cold October day in a county courthouse. She put her hands in her pockets. She walked out of Courtroom 4. In the hallway, the light was the ordinary light of a public building. In the afternoon fluorescent flat, the light of a place that processed serious things without requiring the serious things to be beautiful. Bea stood in it for a moment. She buttoned the top button she had left undone. Then she walked toward the exit the way she walked everywhere, at the pace the distance required. Not hurrying, not slowing, her hands quiet at her sides, her coat closed against the October air that was waiting for her on the other side of the door. The drive home took 20 minutes. Bea sat in the back of the car that Margaret Cole Edmonds' attorney, the one who had known about the trust, the one Bea had called from the courthouse steps to tell her it was done, had arranged because Margaret had said, "You are not taking the bus home," after what you just did, and B had not argued. She watched the county go past the window. The fields, the old farmhouses, the particular October light on the landscape that she had been looking at for 30 years and still found worth looking at. Edmund had loved this drive. He had always taken the longer route home from town, the one that added 10 minutes and went past the ridge where you could see 3 counties on a clear day. She had teased him about it in the early years. Later, she had simply expected it had oriented herself to the longer route as the correct one. The driver took the shorter way. She did not say anything. She looked at the fields and thought about Edmund and thought about Courtroom 4 and thought about the coat across her lap lighter now without what it had been carrying, just a coat, just the weight of good wool and the absence of 23 years of kept faith. The house was as she had left it. She had been gone since 7 in the morning, had dressed in the dark, had eaten nothing, had driven to the courthouse with the coat over her arm and the silver scissors in her pocket and the specific quality of readiness that was not the absence of fear, but something past it. The house had the stillness of a place that had been empty for a day and was waiting. She unlocked the front door. She went inside. She stood in the entry hall for a moment, the hall with the black and white floor tiles. Edmund had chosen the hall with the table where she had always set the mail, the hall where she had stood on the morning after Edmund died, and understood that the house was the same and everything in it was different. She went to the windows. The first one in the sitting room, she opened it. The October air came in cool and direct, carrying the smell of the garden and the distant sound of the mill. The dining room window, the library window, the kitchen window above the sink, the one that looked out over the back garden where Edmund had grown tomatoes every summer, with the specific stubborn optimism of a man who acknowledged that the climate was not quite right and planted them anyway. She opened every window in the house. She went to the study last. It was as she had left it since Edmund died, which meant as he had left it, because she had not been able to bring herself to change the arrangement of it, had kept the books on the shelves in the order he had placed them, and the pipe on the stand where he had set it, and the lamp at the angle he had preferred. The smell was still there. Not strongly. 3 years had softened it the way time softened things. But present, the specific combination of old paper and pipe tobacco, and the wool of the armchair that she had reupholstered in green. She crossed to the armchair. She took off the coat. She laid it over the arm of the chair, Edmund's chair, the one he had sat in every evening, the one that still held the shape of him in the way that chairs held the shapes of the people who had used them long enough. She stood back. She said, "It's done." She said it quietly, not loudly, not for any audience. The way you said something to a person who was not in the room but was in some sense present in it. The way she had been saying things to Edmund for 3 years, in the moments when the house was quiet, and his absence was specific rather than general. She said, "You were right. It held." The letter from Reginald was on the hall table when she came back downstairs. It had been slipped through the mail slot, not sent delivered by hand, which told her something about the state he had been in when he wrote it. She picked it up. She read it. It was short. It said, "You won. But don't think for a moment you deserved it. You were a seamstress. You were never one of us. Edmund was confused, and you took advantage of that for 30 years, and now you have what you wanted, and I hope you understand what you've done." She read it twice. Then she set it on the table. She looked out the window at the mill in the middle distance, its brick exterior, the same color it had been when Edmund's grandfather built it, its windows lit in the late afternoon, because the second shift was running, because the work continued. The way work continued, indifferent to the events of Courtroom 4, indifferent to letters slipped through mail slots proceeding at the pace it had always proceeded. She thought about Reginald's question. "Do you think you deserved it?" She thought about 60 years of work, about the alterations shop on Millbrook Street and the $300 and the second-hand machine, about Edmund walking through the door with a jacket that needed a new lining, about the years of the marriage, the ordinary years, the difficult years, the years of his illness and her care, and the specific weight of loving someone well, when loving them well required most of what you had. She thought about the trust document in the lining of the coat. About Edmund in the study in 2005, explaining every clause, wanting her to understand what she had, not just that she had it. About the night she had sat at her sewing table with the needle and thread and had done the most careful work of her life. She thought Edmund did not ask whether I deserved it. He asked whether I would keep it safe. Those are different questions. She did not write back to Reginald. The Callaway Sewing Academy opened in the spring. 3 rooms on the ground floor of the East Wing rooms that had been used for guests who rarely came and storage that had accumulated over decades. She cleared them herself over the course of the winter methodically, and without hurry, donating what could be donated and discarding what could not. She brought in 8 machines, good ones, the kind that lasted. She sourced fabric and thread and the specific supplies that a beginner needed to learn correctly. She found 3 instructors, women who had spent their lives in the trade and knew how to teach it. She made the sign herself. A length of oak board, sanded smooth, the letters cut cleanly. Callaway Sewing Academy, where your hands tell your story. She hung it at the gate on a Tuesday morning in March, when the first class was scheduled to begin. 8 women came through that gate on that morning, women of various ages and circumstances, women who had seen the notice at the library or the community board, or had heard from someone who had heard from someone else. She stood at the front of the room and looked at them. She said, "You don't need to know anything to start. You need a pair of hands and the patience to use them correctly. Everything else comes from practice." She said, "We start with a straight seam. It sounds simple. It is simple, and everything you'll ever make begins there." In the evenings, she wore the coat. Not every evening on the cold ones, the ones when the autumn came through the windows, she kept cracked because she liked the air. She wore it the way she had always worn it, because it was warm and because it was hers, and because Edmund had given her the yarn for it with the specific care of a man who paid attention to the things the people he loved liked to do. The lining was different now. She had re-sewn it in the winter, not to hide anything. There was nothing left to hide. But because a coat with an open lining was a coat that needed mending, and she was a woman who mended things. The new stitches were identical to the old ones. 114, even, tight. The thread matched exactly. She had counted them. Some habits were worth keeping. She stood at the window of the study on an evening in late October. The coat on the mill lit in the distance, the house warm around her. The coat on the armchair upstairs. Edmund's pipe on the stand. The trust document certified and returned by the court in the folder on the desk where she could see it. She put her hand to the lining. She felt the stitches under her fingers, the new ones smooth holding. She thought this is what 60 years of work looks like. Not in any single thing, in the accumulation, in the knowledge that your hands know what they are doing and have always known, and that when something needed to be kept safe, you knew how to keep it. Edmund had known that about her before she had fully known it about herself. She thought that is what it means to be seen. She looked at the mill. She looked at the coat on the chair. She looked at her hands. Then she went to make her tea, and the house was quiet. And outside the mill ran on, and the October night came down over everything the way it always did, without hurry, without drama, in the specific, patient way of things that have been doing what they do for a very long time and intend to go on.